Welcome to the Appellate Division. We have almost 4.5 hours of argument time requested, so ask for the time that you need, not that you want. If we have further questions, we will keep asking them, and we are familiar with the briefs and the records in each case. People versus Stevens. Appellant? Respondent? 5-1 and 5. Yaquilin versus Bellarminio is submitted. P. Diego is submitted. Gomez versus AHC Properties? I'll give you 3 minutes, but we have further questions. We'll keep asking. Roth and Roth versus Long Island Railroad. Appellant? Respondent? 6-1 and 3. U.S. Bank versus DLJ Mortgage Capital. There's two cases, but we're going to hear them together since they're overlapping issues. I see 4 people standing up, but there's only 3 parties, right? Okay. The request is granted. Okay, so I'm going to grant 7-1, 7-1, and 7 for AmeriQuest. Again, if we have more questions, we'll keep asking them. People versus Espanol. Appellant? Respondent? 5-1 and 3. Corbex versus New York City Housing Authority. Appellant? Respondent? 5-2 and 7. People versus Pagero. Appellant? It is submitted. Dape Consulting versus Next Trucking. 3 minutes. Jawara versus Araka. Appellant? It is. Okay, there's no respondent here? No, I know, but respondent's not here, I'm just confirming. I'll give you 2 minutes. FGNN Trust is submitted, and Thuku versus 324 East 93rd is submitted. So our first case today is People versus Stevens.
May it please the court. Frank Shao for Mr. Stevens. Mr. Stevens stood outside an apartment while his co-defendant climbed through a window and stole some items while the occupant was asleep. His conduct was wrong, but it didn't warrant a 2-year consecutive sentence. And that's especially so given that the co-defendant received only a 1-year sentence. Whatever danger you thought Mr. Stevens posed by waiting outside the apartment, his co-defendant posed a greater danger and played a more culpable role by actually going inside. And so that's why we're asking that you modify.
Isn't there a number of different crimes actually that were charged though, and this was basically a plea that covered many different incidents? But you're focusing on one incident, but there were many others that were involved in the plea.
That's right, Justice Kern. There were other incidents, but those
Many
were...
others.
Yeah, there were several others. That's correct. Sorry?
On 17 different days, as I recall.
That's right, Your Honor. But these were all covered by his pleas to separate charging instruments.
Right, but you're arguing about that the one incident wasn't really that bad an incident, but there are so many incidents, so just focusing on one seems an inappropriate argument.
Well, I do think that those separate incidents were properly accounted for by his separate convictions. And I'll note that the relevant sentencing statute, Penal Law Section 70.25, it actually says that in these circumstances, you should apply a concurrent sentence if either there are mitigating circumstances that bear on the manner in which the offense was committed, or if there are multiple co-defendants, if the defendant's role was relatively minor. And here, both of those factors support a concurrent sentence because, again, if you look at the manner in which this offense was committed, a co-defendant went in and took some items while the occupant was asleep. So there was no use or threatened use of force. And then,
Just a question. Now, you say it's passive, but, how can that be? Because wasn't he outside, like, catching the items as they were being thrown out the window? So that's a little more than passive.
well, I won't fight you too much, Justice Kennedy, on whether it's passive or not, but certainly it's less culpable, I think, than the person actually going in. And if the person going in gets a 1-year sentence, I think it's hard to justify why Mr. Stevens should have received a 2-year sentence.
Do you want to address the plea waiver?
The appeal
The
waiver?
appeal waiver?
Yeah, sure. So the appeal waiver here is invalid because Mr. Stevens gave up his appeal rights in exchange for nothing. There was no mention of an appeal waiver during the plea negotiations. And so Mr. Stevens didn't even hear about an appeal waiver until the middle of the plea colloquy, after he had already, in exchange for the promised sentence, admitted that, yes, he had attempted to burglarize this apartment. And so I think that kind of gratuitous waiver simply can't be enforced. Now, I know respondent makes much of the fact that at the time, the court hadn't formally accepted the plea. And so in theory, yes, Mr. Stevens could have called off his plea if he didn't want to agree to the appeal waiver. But I'll say that that argument is unpersuasive for 2 reasons. The first reason is that that kind of formalism simply isn't supported by the case law. Rather, the cases make clear that the touchstone of the analysis is whether the defendant received any material benefit by giving up his appeal rights. And here, it was impossible for Mr. Stevens to derive any benefit from giving up his appeal rights because the plea negotiations were conducted and concluded without any mention of an appeal waiver. And then the second point I'll note is that, respondent says, as a practical matter, yes, Mr. Stevens could have still called off the plea. But I'll just say that that defies the practical reality on the ground. Because once the defendant admits in open court to his guilt, there are going to be virtually insurmountable psychological and strategic barriers to calling off the plea. On the psychological point, I think it's very difficult for someone to, in one breath, say, yes, I'm guilty, and then in the next breath say, actually, wait, never mind.
Is there any research on that, or is this just are you arguing from common sense?
Yeah, I'm drawing from just, everyday kind of lived experience. I think certainly I would have difficulty, in one breath saying, yes, I'm guilty, and then in the next breath saying, actually, wait, never mind. But then on the strategic point, once the defendant admits guilt in open court, even if he later retracts that statement because, again, he's sandbagged with this appeal waiver, that even admittedly retracted admission of guilt is going to be a powerful bargaining chip in the prosecution's hand to leverage to a more unfavorable plea offer. So I just don't think that it's realistic to expect that any defendants are going to be able to call off their plea in these situations. And then I'll just maybe a final note about the appeal waiver is that I think if you bless the appeal waiver here, there's going to be nothing to stop prosecutors in other cases from following the same exact playbook. They're going to negotiate a plea with the defendant out of court without mentioning an appeal waiver. But then at the last minute, in court, in the middle of the plea colloquy, after the defendant admits guilt, they're going to sandbag the defendant with an appeal waiver and tell him you can take it or leave it.
Thank you.
Good afternoon. May it please the court, Christopher Marinelli for the people. Justice Lorenzo did allocute the defendant through a textbook oral waiver of his right to appeal, and defendant swore under oath he understood it. He did not need further time to discuss it with his attorney, and he was waiving his right to appeal of his own free will.
Could you address the timing question raised by counsel?
Sure. The touchstone is, as the Court of Appeals has made very clear, totality of the circumstances. And what this court has said and what the Second Department has said at times is, yes, maybe the better practice is to discuss the waiver first before the factual allocution of guilt. But, I would say the formalistic argument is there's a bright line rule, and there isn't. You have to look at all the circumstances. I don't think the fair reading of the record is the defendant was sandbagged in the middle of the plea colloquy. When his attorney brings it up, she just says the people didn't include the waiver in an email. She doesn't say, this is the first we've heard of it. And the judge says, well, what do you want to do? And she says, well, of course we want to proceed. So I think on the totality of the circumstances, it absolutely is a valid waiver. I would note that somewhat ironically, although, again, this court has advised maybe the better practice is to do the waiver first, the model colloquy actually lays out the plea exactly like this. And I absolutely don't think it's fair to conclude the defendant was in any way sandbagged. I think it was absolutely an enforceable and appropriate waiver. If you have no more questions on the waiver, I would just say on the merits, as it were, 6 felonies in satisfaction of 8 charging instruments, nearly a score of individual crimes. So you suggested, it's really not a fair metric to look at the disposition of what happened for the co-defendant in just one of those crimes. I would say the best evidence we have on this record, I don't concede this record established that the defendant was less culpable. I think the best record we have about the propriety of the sentence is defendant agreed to this sentence, and the same judge sentenced both this defendant and the co-defendant and found the co-defendant qualified for the alternate definite minimum sentence of 1 year rather than a 2-year term. And finally, I just say that I don't think it would be remotely fair to essentially say defendant should serve no time for this burglary. These crimes, they took place over the course of about 2 years. The first weapon possession, October 2018. Burglary is June 2019. The second weapon possession, June 2020. Consecutive sentences were absolutely appropriate and just in this case.
Thank you.
Thank you.
So just 2 brief points, Your Honors. First, on the idea that my client would serve no time. If the court were to modify his sentence today, it would mean that Mr. Stevens would have served a total of 5 years in prison. And so he would have effectively served a 1-year consecutive sentence if he were to modify his sentence to run concurrently. And so that's not at all a windfall here. Second point, just briefly on the appeal waiver, my adversary he referred to a couple of cases where the courts have said, there's some flexibility in the sequencing of when the appeal waiver is discussed. We have no quarrel with that, but in all of those cases where the appeal waiver was discussed after the factual allocution, it was undisputed that at least the defendant's lawyer had discussed the appeal waiver with the client. And so in those cases, there was often already a written waiver form that was signed and executed way in advance of the plea colloquy. And that's simply far removed from what we have here, whereas I think the record quite clearly shows there was no discussion at all of an appeal waiver until then. Thank you.
Gomez versus AHC Properties.
Good afternoon, Your Honors. My name is Mitchell Giddin. I'm here for the Appellate law firm. Just very briefly, we sought leave to appeal.
Counsel, we're familiar with the case.
Of course.
I guess I'd like you to answer what kind of discretion the court does have. If the court didn't make that statement in the email and it just decided that in this particular case no reimbursements were reasonable, would there be a basis for challenging that?
No, if there was some discretion exercised and a reason given, okay, then one has an opportunity to respond to it and to defend. And in this case, the reason we asked the court to grant the application or to modify to grant the original application made is because the forensic expert, the neuropsychologist, was necessary. Would have been necessary if the case was tried.
So if the court has broad discretion, which it obviously doesn't in compromise orders, and I know the main thing you relied on was the judiciary law, which doesn't even apply to personal interaction, so we can't rely on the judiciary law to support your argument. But putting that aside, why can't a court say, I have broad discretion and I've made a determination in infant compromise orders that because we have such a high interest in protecting the child that we're not going to allow disbursements in these cases?
I guess in a word, I would say that the Supreme Court judge is not the policymaker for the department or for the state. We're aware of no other judge or court that takes this across the board. I mean, to be strict about them, to have rules.
So the issue really isn't the discretion, because we understand that in at least through the administrative code, there is discretion. Your issue is that she didn't put that on the record.
Well, the issue that she abandoned, I like to say the court abandoned its discretion okay, refused to exercise, or declined, I should say, to exercise any discretion as the rules directed to do. And if that's going to be a policy choice by a single judge, we would want to defer to this court or, the OCA.
What happens if she had instead said, I reviewed the disbursements in this case, and based on my review of the disbursements, I find that no disbursement should be reimbursed?
Well, we would say that,
Would that be satisfactory to you?
I don't think so. I mean, well, you can say anything. Let's put it this way. I think the court, I'm going to assume that all the judges are acting in good faith. And if this court, for instance, and just go on the precedent of the experience of the courts, that there is examination of discretion. That would be unacceptable to say that, because it would just open the door to, I don't say my firm or any firm, but there would be a lot of suspicion that one tried to get a settlement before a different judge. There were places where there were trial terms. I mean, you come to the tap part and there would be a scramble, especially when there's a lot of money at stake. Now,
I have another question. So let's say, just in general, right, the court exercises this discretion. So now, normally, when you're looking for reimbursements, you first take that off the top, right? And then you get the 1/3.
there's always the option 1 and 2, and this one happened to be option 2, but whether that, depending on if it's a small case and settles for quote-unquote nuisance value, there's different advantages. But the difference here comes to about $3,000. I calculated it out. But what I would say in response to what I think all your honors are kind of asking about discretion is that just the wording of the order that granted leave to appeal to say insofar as the disbursements were denied in toto. So if it is a discretionary thing for a judge, you granted leave to appeal, I would ask this court respectfully to exercise its collective discretion, and if those disbursements are deemed fair,
They're not remanded. Why would we get into exercising our discretion as opposed to just remanding it if we were so inclined?
could remand it. That would be my second request. We'd like to get it done because, again, there's judicial economy at stake. It's taken a while, but that's okay. I mean, remand is, as long as it would be a directive, because I'm confident that if the judge the part was instructed that some evaluation is required, then let the chips fall where they may. We can make the case.
Thank you very much.
Thank you, Judge.
Roth and Roth versus Long Island Railroad.
May it please the court, David Roth, on behalf of Roth and Roth, petitioner and appellant. This case is about a FOIL request that was responded to with accident reports. The accident reports were redacted initially, despite respondents' papers. They were redacted with all identifying, including even the date of accident.
And why wasn't it appropriate for the court to allow that redaction based on the privacy exemption? What was incorrect about that?
Well, two things. One, it was never asserted in the administrative process, and so they had waived
Well,
that.
I mean, it does have an interesting procedural history, but there would have been no opportunity for them to assert it earlier because they earlier said they didn't have the documents. It wasn't till you brought the motion to re-argue at the court level that it first came to light that these documents even existed. So there never had been an opportunity at the administrative level.
Your Honor, I'll address that in the merits, although I would say that once they got busted, they produced it, so they could have done,
Right, but they
could have
couldn't
done
have
something.
raised it earlier.
But they could have responded or done another FOIL response and say, hey, here's our FOIL response, and we would have dealt with it. They chose not to do that.
Okay, and what's your
But in
response
any
on the
event,
merits?
that all we are asking for is the same information that is contained in any police report, name and address. Because if you take this, why is a transit authority any different or the MTA any different than a police report? So there's an accident, and Judge Kelly, and it's in my papers, he said, hey, there should not be a code of silence.
The police report, it's a different analysis under FOIL. It's not usually an analysis where it's sent to the police and anyway.
When the police show up to an accident, they take the names, they take the addresses. All we're saying is names and addresses are not, there's no expectation of privacy. They have not cited one case where somebody's name by itself, they keep looping in the name, the social security number, and we're not looking for dates of birth.
Right,
We're
but
not looking for social security
you're trying
numbers.
to find out about accidents that happen within a certain location. you have the date and time of those accidents. What is the purpose of the name beyond that? And understanding that things that you might get in discovery are different than what happens here underneath the oil.
Your Honor, what I would tell you is that on page 456 of our record on appeal, here is their accident report. There is not enough information for me or any other plaintiff in the city of New York to come in and say under Daniels or the recently decided case Pollack to show that this incident was substantially similar based on this report. So, and by the way, this was
But
produced.
why don't those people have an interest in you not contacting them and saying, hey, we want to get information about this from you so we can pursue this own different lawsuit that's not your particular incident? Why don't those people have a reasonable expectation of privacy and not being, which is what I assume you would do. I assume if you had their information, you'd contact them and say, hey, give us more details so we can argue that our case is like yours.
Your Honor, those people are all they're claimants, they're complainants, they're witnesses to the accident.
Well, no, they're not about the accident you're suing on, though. There are other accidents that may or may not have any relationship whatsoever to the accident that you're concerned about.
Your Honor, this court and Daniels and the Court of Appeals has said that, especially for GAPs, literally GAP accidents, system-wide are notice of an incident. There's not enough information in these to establish that. And I'm saying is they have a motivation because if you look on page 16 of our brief, when it's convenient for the Long Island Railroad, they publish witness information. They put on the court docket, here's the name, the address, even the hospital. And we have 4 cases where they did that. Excuse me?
You said on a court docket. If it's on a court docket, then they've already voluntarily gone to court. That's a
No,
very
this is other people. They're putting witness information. They're citing in my brief where when it's convenient for them, because like I said, as I said, why would they redact date originally? It's not like they unredacted the date, okay? So because they don't want us to have that information. So all I can say is in response to that is that the Long Island Railroad doesn't get to pick and choose when a name and address is, whether it's privacy sensitive or not. Even for discovery, if you really believed it was privacy sensitive, name, address, and witness information, when you filed it on the court docket, you'd redact it, and then you would send an unredacted to the plaintiff. But here, they don't do that because it's for this purpose, that they don't want to have any other witnesses, and they know that I don't have enough information to get the other accident information from this based on
You keep
what they've
saying
given us.
witnesses. Are you saying witnesses to this particular accident?
The condition of their notice, this goes, generally in a GAP case, I litigate tons of them, you want to show that they know the GAP is dangerous, that people are getting hurt. What is negligence? You know there's a dangerous condition. Did you have a reasonable time to fix it? What steps did you take to fix it? Was it feasible? So those things, and the Court of Appeals said, hey, even if you find that, you got to show that that GAP is substantially similar. These reports, like they said, I have enough. We don't have enough because these reports don't contain enough to make that burden of proof. So what I'm saying is that there's a motivation behind this redaction that's not privacy, because if it was privacy, then when they themselves had stuff, they wouldn't put it up on the court's docket, which is subject to everybody and certainly more accessible than my personal files, as to answer that question, Your Honor. So, and as I said, they didn't assert any of these other objections. And as far as there's one other thing in their asserted objections, they say solicitation. They come up with the solicitation, HIPAA, and privacy. HIPAA is not applicable. It's not an applicable entity. Solicitation is just offensive. They're saying that I'm going to go and try to solicit people to be my clients. The statute is long expired. I mean, if they want to say you're soliciting them, they could be possible witnesses against us at a trial, then yes, that's true, but that shows motivation.
Thank you.
May it please the court, Ronnie Shulman on behalf of the respondents, Long Island Railroad.
Counsel, following up on what counsel said, why do individuals who are either are part of an accident on the LIRR or witness to an incident on the LIRR have a greater interest in privacy than individuals who have a car accident and call the police and their names are in the police report?
Well, I think a main distinction here is the request through FOIL and then obviously that leading into an Article 78 proceeding versus a general plenary action in discovery. So
I'm not talking about a plenary action and discovery. I mean, you can always discover a police report, and that reveals the name of the people who were in the accident or who were witnesses to it. Why shouldn't the same information be available as to people who were in or were witnesses to accidents on the LIRR?
I think that it's important for a petitioner, generally requesting a FOIL request, that when they make that request, they have something involved with the request for the witnesses' names. In this case, these witnesses aren't witnesses to appellant. These witnesses aren't connected in any way to any litigation or underlying litigation to which appellant is involved
Well,
in.
they don't know that, right? Because there's an issue with a gap or some kind of, and if there's an incident report, why are they allowed to point out?
As appellant mentioned many times in his original brief and reply brief, his intention is to find some sort of negligent act or lack of notice or notice in terms of what the LIRR was doing in terms of gaps or any other defect that might be on the platforms themselves. What appellant has in his possession currently have records dating back to 2010 with incidents that may or may not relate to the incident that he's involved with in the litigation, but these particularly reports give him everything he needs. They give him the date, as your honors have said. They give him the injuries. They give him the locations. They give him everything that he needs to know in order to make a determination as to whether or not there was a defect at that location.
Now, counsel mentions that the MTA also raised the solicitation exemption, but this exemption, you didn't invoke this before, correct?
That's correct.
Or any of the other additional ones in your brief, right?
It wasn't explicitly invoked. However, it was invoked in our reply opposition to his motion to re-argue or reconsider, given the new evidence that came to light.
But initially, it was focused on the privacy exemption, right?
Privacy exemption and HIPAA, yes, that's correct. But the privacy exemption in subsection 87.2, may I proceed?
Yes.
87.2b was broadly used in the FOIL response when these ARNI reports were given to appellant. If you look at 87.2b, you'll realize that there's an enumerated list. And then if you look at matters of New York in the Court of Appeals, we'll see exactly that if none apply, that we make a balancing test. And I think that's where this case relies on. Whether or not the privacy interests of an individual, innocent, uninvolved party outweighs those of an appellant who's a part of a litigation to try to gain information that he already has. Their names, their addresses, their dates of birth, that's private.
Thank you. Go ahead.
I still don't understand why those witnesses are entitled to more privacy than a person who is a witness to a car accident. And it might be that somebody does a FOIA request for police reports on car accidents on that corner, but those would result in getting called up, and those people's names would be on the police report. Why is that different for somebody who witnesses an LIRR accident?
I would agree with Your Honor in the context that the petitioner in that matter, let's say, would be an involved party on the other side seeking information to contact these witnesses, or not just contact them, but to have their names because there's an ongoing litigation. Here, there's no connection. A lot of the cases that are brought up in the
Are there any
briefs.
cases that actually talk about police reports in the context of FOIL? I mean, I'm not sure if we're talking apples and oranges here. Did either party cite to any cases where they discuss whether police reports of other incidents in the same location are discoverable under FOIL?
No, Your Honor.
Okay, so we don't know what would happen in a FOIL
No, this-
FOIL situation where the police are being asked the same thing you're being asked, because there's no cases that address that, right?
Oh, there are cases that address FOIL requests to police departments or district attorneys' offices for information regarding particular witnesses in
that case, but not this type of request.
No, this type of request is involving a petitioner or appellant who's asking and seeking witness information
There's
that's
no
completely
equivalent.
unrelated.
There's no equivalent case having to do. Okay, thank you.
Unfortunately, I couldn't find anything, Your Honors.
Okay, thank you.
Thank you.
quickly, on page record 14, M. Farbman and Sons versus New York City Health and Hospitals Corporation. This is Hornbook law. FOIL does not require that the party requesting records make any showing of need, good faith, or legitimate purpose. That is not part of.
No, but that's not what we're talking about. We're talking about privacy interests. What does that have to do?
But counsel's acknowledging that the whole thrust of their argument is the purpose. The purpose is irrelevant. The purpose is whether or not names and addresses, and I would say Friedman versus Rice, the Court of Appeals case, makes it very clear, unless you have an expectation of privacy, there's a promise, you're a confidential informant, then yes. But otherwise, there's no, in New York State, there is no expectation of privacy of your name or your address or anything else. So yes, date of birth, social security number, specific medical information, of course, and we're not asking for that. And to the extent that there's any clarity, I will clarify now, it is limited to names and addresses, and that's it.
Thank you.
But you have the injury, right? Is the injury included with what they've provided? Did it include the injury?
It included the injury, but that they could have redacted that, they chose not to. But regardless, they know what they know for sure is that these documents, which is all they provide to me, unless I can get more, they're unusable.
Thank you. Thank you very much. U.S. Bank versus DLJ Mortgage Capital. And AmeriQuest should go third, okay? Because you don't really have a cross appeal.
Thank you, Your Honor. So the three sets of claims that the court dismissed are all claims for breach of rep and warrant regarding the loans in this trust. And they are all subject to a contractual repurchase protocol that says that if AmeriQuest, which is the entity that originated the loans, discovers a breach of rep and warrant or is notified of a breach of rep and warrant, it gets 90 days to cure the defect or repurchase the loan. And if it doesn't, then the trustee can sue. The same contract says that DLJ, who securitized the loans, has to repurchase the loans if AmeriQuest fails to repurchase the loans. And importantly, the trustee can sue on the same loan under either a notice theory or a discovery theory or both.
Well, are you talking about your claim that there's discovery, that even in the absence of a notice that you can proceed on a discovery-based theory?
Well, that was the background, and I want to turn directly to the discovery-based claims
Well, what is the
first.
thing that you want to focus on first?
Discovery-based claims first.
Okay, well, let me ask you first about the discovery-based claim. Why should we even consider that at this point in the litigation, since reviewing the pleadings, there doesn't seem to be any discovery-based claims that were ever asserted in the pleadings?
There is a single claim for breach of rep and warrant. The discovery or notice is simply part of the contractual prerequisite.
But it's only discussed in terms of whether or not it supports a claim for a notice-based breach. There's no separate claim stated in the complaint that says, hey, we're suing for, for a discovery claim in the absence of notice.
Your Honor, the pleading standard is very clear. It is still a liberal pleading standard. All the allegations have to be read in our favor. This court has held, the Court of Appeals has held, that it does not matter if or how we label the allegations. It doesn't matter what language we use, as long as we state the facts essential to the cause of action. And we did that here. We pled the defendant's duties. We pled AmeriQuest's contractual obligation to repurchase upon discovery, independent discovery of the notices. We pled DLJ's obligation to repurchase as a backstop. We pled that AmeriQuest discovered the loans.
Okay, well, let's say we do address it, even though arguably it was never asserted or even argued below. It's being argued for the first time on appeal. Don't you still have the same requirement of the condition precedent for discovery-based obligation of a notice of discovery deadline? And how did you satisfy that?
We don't. The notice of discovery condition, we say, only applies at best, to notice-based claims. It would make no sense to apply it to discovery-based claims. The notice of discovery condition, sorry?
Why? Since it's a condition precedent to bringing suit, why wouldn't you have to comply with it in any suit you're bringing
The repurchase protocol is a condition precedent to bringing suit. That says if you discover a breach or are notified of a breach, then you have 90 days and the trustee can sue. That's the repurchase protocol. The notice of discovery condition is not part of the repurchase protocol. It is a odd little provision that is tucked into this particular contract, which we say is not part of the repurchase protocol. It's ambiguous for reasons I can get into. But at best, what it would mean is if you're suing on a notice-based theory, then that condition applies. It would make no sense for it to apply in a discovery-based theory. Under their reading, the notice of discovery condition says that they don't have to repurchase something unless the trustee, upon discovering something, notifies. But these claims are based on AmeriQuest discovering. What they're saying is if AmeriQuest discovers a breach, it still doesn't have to do anything unless the trustee over here discovers the breach and then notifies them within 90 days. We think the contract doesn't say that, and it would make no sense to apply it. It would basically make the repurchase protocol meaningless. On the discovery-based claims, we think we've met the standard, and very importantly, the defendants don't identify a single other fact that we should have pled in order to state these claims. We plead the contractual obligations, we plead a breach of the duties. That is all you need under the pleading standard, and we did argue this below, Your Honor, to be clear.
These allegations were only brought up in the context of failing to notify of the breaches should be excused, that the failure to notify should be excused. That was the only context in which they were brought up.
Your Honor, the pleading standard is still clear. If we identify the contractual obligations.
Don't you have to assert that you're actually bringing a cause of action, though?
We have to.
based on that claim?
We did. We asserted a claim for breach of rep and warrant. There's not a separate claim for discovery-based breach of rep and warrant or a separate claim for notice-based breach of rep and warrant. The claim is breach of rep and warrant.
Do you want to address anything else?
I do want to address several other claims if I could get to it. Just to finish this point, though, the discovery and notice, as the Court of Appeals has told us, is not part of the substantive claim. The claim is breach of rep and warrant. We pled the contractual obligations in the breach.
So your
the
point
repurchase
is
protocol is separate.
Said the larger argument, so underneath it, all of these matters.
Yes.
They were specifically.
We pled every single thing we need to plead, and we've laid out in our papers what the contract requires, the discovery of the breaches, the failure to repurchase is a backstop. The pleading standard we think is clear as day that that's all you need. But let me turn to our two other buckets of claims here. One is the 2019 notice-based claims. These are based on notices that AmeriQuest received in 2019 for about 900 loans. The only question here is whether the trustee complied with the contract's procedural prerequisite the defendants get notice and 90 days to cure and repurchase before we filed claims, and we did. Now, the court below dismissed it based on a misreading of heat decided by the Court of Appeals. The court below said that the contract does not require defendants to repurchase based on notices received after the original complaint is filed. But we think that is not what Heat said. The concern in Heat from the Court of Appeals was that the defendants have to get 90 days after receiving a notice in order to cure a repurchase before the trustee files a claim.
Pre-suit.
They use the term pre-suit, but what that means in context is pre-claim, pre-operative complaint.
How are you getting that? It seems like the cases are pretty clear that they really do mean pre-suit, and pre-suit is pre-suit before the action is actually commenced.
There are several points, Your Honor. So number one, in Heat itself, right? In Heat itself, the court faulted the trustee for not filing an amended complaint. The court said the trustee did not attempt to invoke CPLR 203F after filing an amended complaint to add new claims following satisfaction of the condition precedent. But that the trustee did here in the 2015 action exactly what the Court of Appeals said we should have done there. We filed these notices. We waited 90 days.
Argument for the 2019 action, but
Sorry?
I said that might be a better argument for the 2019, but you'll have time on rebuttal to address.
Could I get 60 seconds to address the 2012 notice-based claim?
No, on rebuttal.
All right.
Daniel Rubens for DLJ Mortgage Capital. On the independent discovery issue, I agree with Justice Kearns.
No, I don't agree with me because I'm just asking questions.
Oh,
So
well,
I
the
never
question-
like when I hear that someone's
Right.
agreeing with me.
Well, they didn't plead that claim for the reasons that were discussed. This isn't an issue of a liberal.
Why wasn't it sufficiently pled? Since our provisions for notice are very lax in terms of what has to be pled or how it's to be pled, why shouldn't we allow it to go forward on the ground that they did talk about it? in the complaint.
It's not an issue of liberal pleading standard. It's that they affirmatively chose to plead the claims based on notice. And these are two different types of claims. The court said so in Greenpoint. It said so in Natixis. And the plaintiff here was aware of how these are different claims. The failure to notify a claim that's the subject of our cross appeal shows how you would have pleaded such a claim. And this relates to another point that's very important. The independent discovery is not a basis to trigger DLJ's backstop obligation. Contrary to my adversary's presentation.
Why not?
That's what the Supreme Court held in the prior action on page 960 of the record. Justice Friedman dealt with exactly that argument, and she said that any independent obligation for discovery does not excuse service of a repurchase demand on AmeriQuest. And that's,
Excuse, I'm sorry, what?
she held any independent obligation that AmeriQuest may have, referring to independent discovery, does not excuse service of a repurchase demand on AmeriQuest, precisely because the PSA expressly conditions DLJ's backstop obligation.
So basically, the same requirements would apply whether or not it was a discovery obligation versus a notice.
Certainly with respect to DLJ's backstop obligation under the PSA, and this
And
court...
since it wasn't satisfied, that's your argument why, even on the merits, if we were to consider it, there wouldn't be.
Exactly, and I would just note this court affirmed that motion to dismiss ruling the prior
Let me
action.
ask you about the 2019 action. So one of the big issues in this case, obviously, is the timing of when these notices are given. And at least your argument is that it has to be given pre-action being commenced, and that's part of the reason why the 2015 action has to be dismissed, because it was given after the action was commenced. What, though, about the 2019 claims? Because in those claims, it's clear and undisputed that the notice actually was provided before the action was commenced. So why can't those claims go forward?
Because
Why shouldn't they be allowed to go forward?
when the Court of Appeals in the Heat case was disapproving post-suit notice, it was referring to notice given after the commencement of litigation. So whether there's a refiled 205A action...
So I'm having a little trouble hearing you, so maybe you need to slow down or go more
Okay.
closer to the microphone.
Whether there's a refiled 205A action doesn't affect that disapproval of post-suit notice. That's what the Court of Appeals was talking about in the Heat case when on page
The
1...
court said that your remedy is to go bring a new claim, and it specifically said that CPLR 205 would apply to those claims. So why, if it's a new, the 2019 is a new, it's a new suit, and 205 does apply, so why doesn't that remedy that issue?
Because the court discusses the AHC decision by the Court of Appeals in this case, which was referring to 205A, and in Heat, the Court of Appeals said nothing in that AHC decision approves of post-suit notice. So it had before it the same arguments
But
that...
that would be for the 2019 claims that were included with the 2015 action, but not the separate 2019 claims. Is that right or wrong?
What the Court of Appeals was talking about in Heat disapproves of notice after the commencement of litigation on the trust. So that, in this case, refers to both actions, because what's happening here is that trustee is using a notice filed in 2019 to significantly expand the universe of loans at issue. That was the issue before the Court of Appeals in Heat, and the Court of Appeals could not have been more definitive in disapproving of post-suit notice, including by referencing...
This isn't post-suit notice, arguably. For the 2019 claims, the notice was given prior to the 2019 action being commenced. So it's not post-suit notice. It's just a use of 205A to be able to bring a new cause of action. But definitely the notice was given before that action was commenced.
As I read the Court of Appeals decision, it's referring to notice given after the commencement of litigation on the trust. So from that
I
perspective...
mean, any litigation.
Yes, whether
But
it's...
don't they specifically talk about in Ashby about applying CPLR 205A, where the prior action was dismissed for failure to comply with the contractual condition precedent? It approved the use of CPLR 205A.
But the
Why
Court
doesn't
of...
that fit squarely into our situation?
Because the Court of Appeals said, quote, nothing in that decision approves of post-suit notice.
But if we were to
You're saying, go ahead.
just go based upon what you're saying, it applies to any litigation on the trust. I mean, just follow that through to its logical conclusion. That would prevent any later suit if there's litigation on the trust. I think that it makes sense that if they're trying to refile with the 2015 action and those points there, then yes, maybe you have a point that stands that is pre-suit, post-suit notice. But in 2019, that's a separate action.
So I understand the concern, but I think that this is really the same issue that was before the Court of Appeals. If you take a step back and just look at practically what's happening, the Court of Appeals was considering what happens when you bring suit on some loans and try and get in further loans after the commencement of litigation.
But it's saying that it must be provided pre-suit. So 2019 is the suit, so it's pre-suit.
Well, I don't want to fight the court on that, but I would just point to another decision entered by this court in the Heat 2007-1 case that I think is instructive, disapproving of using CPLR 205A to refile and provide post-suit notice. It was a different issue under a different element of 205A, but that's 209 Appellate Division 3rd 553, which we cited in our briefs. And I think that panel, which included Justice Kennedy, recognized that functionally using 205A refiling to get around that holding that you can't expand the universe of loans at issue would basically nullify what the Court of Appeals majority was getting at in Heat 2007-1. So I think here too, this panel should understand functionally the issue before the court, which in the Heat case, which is that you have to provide pre-suit notice on the loans you want to proceed on within the 6-year limitation period. And we're not talking about them refiling the suit and going.
You're saying as a matter of law, they should not be allowed to use 205A to bring the suit pre-notice. Once they don't do it the first instance, they're out.
Right, the relevant time is when they filed on the last day of the limitation period. There was a problem with that notice. They identified 1124 loans. The case is limited to those 1124 loans. That's what the Court of Appeals decision.
What happens if they discover new loans in the interim?
But that was the same argument they made in Heat when they
They're
said.
done forever then?
That's what the Court of Appeals held, in my
Okay,
view.
thank you.
May it please the court, Joanne Davies, appearing today on behalf of the respondent, AmeriQuest Mortgage Company. So picking up on counsel for DLJ's argument on the
Can you move
2019
the mic
action.
closer to your mouth?
Certainly. So the issue with the 2019 action is it is not a valid revival action against AmeriQuest. There was no action dismissed.
You're in a different situation, right, than DLJ with respect to that, because there was no, if they're relying on 205A, that works as against DLJ, but it doesn't work against AmeriQuest, right?
I mean, I would make an argument it arguably doesn't work against DLJ either, because there was a May 2019 action that the trustee dismissed voluntarily because DLJ agreed to proceed in front of the 2015 action.
That arguably works for AmeriQuest. Why does that work for DLJ?
Well, because 205A well, for one thing, it was voluntarily discontinued. And once you voluntarily discontinue, you can't refile.
There was still appeals going on with respect to DLJ, right?
No, the AHC decision had been issued by the Court of Appeals. After that decision was issued, trustees, former counsel, filed an action, the May 2019 action, which is in the record, and then voluntarily discontinued that action. That's in the record at 1015.
That action was against DLJ only.
It was against DLJ only, and they expressly state in that action, the trustee is now filing this action solely against DLJ in accordance with CPLR 205A in an abundance of caution following the final termination of the original action as against DLJ. In essence, they're acknowledging that that action had previously been terminated against AmeriQuest and that they were not including AmeriQuest in their May 2019 action. They then get new counsel, and in August of 2019, in the interim, they serve the May 2019 notices, and then they try and purport to do another 205A revival action, and it's completely improper for both respondents. But certainly for AmeriQuest, but equally for DLJ, we believe. The other issue is that for 205A to work, period, even in the 2015 action, there has to have been a validly commenced action. And at the time that the summons with notice was filed, U.S. Bank had no viable claims against AmeriQuest with respect to the 1,124 loans it was relying on, because it failed to comply with the time restriction set forth in MLPA 7.04. That time restriction says, look, trustee, once you discover there's a breach, you must give AmeriQuest notice within 90 days. That time restriction is repeated 2 more times in the MLPA and other provisions. It's clear that these sophisticated parties negotiated for a limitation of AmeriQuest liability once they learned of a problem. In 7.05, the issue was if the loan paid off earlier than expected. And in that situation, they had to give AmeriQuest notice within 90 days of discovery, or they waive the obligation of payment. Same thing in section 7.06. 60 days after there's been an early payment default, they had to let AmeriQuest know. So it's very clear within the MLPA itself that notice was required. And specifically with respect to 7.04, it says expressly, if you don't provide notice, it's a waiver of AmeriQuest payment obligations under 7.04. So even if they want to look at paragraph 2, which talks about cure or repurchase after discovery or notice, that obligation is waived. And so at the time the summons with notice was filed, there was no viable action. You cannot then lean on that to do a 205A revival action. And for that reason, 205A, be it the 2015 action or the 2019 action, is not available to the trustee. The other point I would make is that from the inception of this case, the trustee has never been making independent discovery-based claims. If you go back and look at the notices, the basis of what trustee was pursuing, they cited to PSA section 2.03, which expressly provides that the trustee, an indenture trustee, who is guided by this indenture agreement, which tells them what their jobs are as a trustee, says you are only supposed to go after AmeriQuest for cure or repurchase after you've provided notice to AmeriQuest. And if AmeriQuest can't cure or repurchase at that point, then DLJ acts as a backstop. When you look at the summons with notice, the only contractual provision cited in that summons, other than a general reference to representations and warranties, is PSA section 2.03. The trial court indicated in his decision that the MLPA's section 7.04 was actually clear on its face in terms of what trustees' requirements were. On the third point, trustees' original complaint, the very wording of its claims against AmeriQuest, it eliminate any inference that independent discovery claims were being brought. If you look at paragraph 30, it states that AmeriQuest's repurchase obligation commences upon receipt of notice of the breach and must be performed within 90 days. That's in the record at 894. The causes of action that trustee alleged focused on PSA 2.03, in fact, only said that trustee had performed its obligations under the PSA. And that, again, that provision limits recovery based on notice. And paragraphs 70 and 84 specifically state that AmeriQuest must cure or repurchase after its receipt of notice. As demonstrated in Greenpoint, trustee knew how to make independent discovery-based claims. It expressly did it in that case, in the summons, in the complaint, and it has not done so here. If you look at the original complaint filed in the 2015 action, it has those same claims talking about AmeriQuest liability being dependent on notice of the breach. And as the trial court properly found, it would be extremely prejudicial to allow the trustee 18 years after the transaction closed and 12 years after the litigation was commenced to add an unknown number of independent discovery-based claims. The defense required of independent discovery is not the same as a notice-based claim. That's obviously why trustees prefer to pursue notice-based claims. They're not the same, it's not the same evidence involved in having to pursue them or to defend against them.
Thank you very much.
All right, there's a lot on the table. I'm going to try to get through as much of it as I can. If I
I'm
could,
going to ask you to focus again on the 2000, not again because you didn't really focus it that much in the first time, but on the 2019
On the 2019
Sorry.
or the 2012?
2019 cause of action.
So go back to the 2019, not the 2012?
Yeah, to talk about whether the 2019 was timely commenced or not.
So 2019 was
Whether you could or could not rely on CPLR 205A to make those claims timely if they were not valid in the first instance.
Well, they were valid in the first instance. That's what the Court of Appeals held in AHC 5. It specifically said that the claims in this case were timely filed, that any argument that the defendants made about whether they were
Right, but
procedurally...
let's just assume for purposes of my question that we find that the 2015 action was properly dismissed. Let's say that's out because of the condition precedent. What then is different about the 2019, or what different argument can you make about the 2019 versus the 2015?
Well, if, again, we say the 2015 claim should be in because the 203F logic applies as much as 205A. But if the 2015 action was out, all the claims would survive in the 2019 action because we filed a new complaint within 6 months of the final disposition of our original appeal, which happened in the Court of Appeals in 2019.
What about the fact that you have to give 90 days notice once you're aware of?
That all happened. So that all occurred. So the trustee gave notice of the loans for these 2019 loans. It waited 90 days. The defendants did not cure or repurchase, and then it filed its 205A complaint that included claims based on those notices within the 60 days.
That you first became aware of them in 2019, that was when
Yes.
you first had notice of these claims?
Correct, Your Honor. And as a practical matter, the way it works is that the trustee is a fairly passive entity. It doesn't have an obligation itself to investigate the loans. What happened was a group of certificate holders, the ones who are the beneficial owners of the trust, they went out and investigated and looked at some of the loans and discovered additional breaches. They then told the trustee, and the trustee then gave the notice, waited 90 days, and then included the claims. So that explains the delay.
Thank you very much.
Would I be able to address the 2012 notice-based claims? I don't think anyone raised it, but those were dismissed as well. 60
You can have
seconds?
30 seconds.
30 seconds, all right. I will
Go
see.
for it.
The only question here is whether the so-called notice of discovery condition bars
That's
those.
what the 2015 was about, the 2012 notice claims, right?
It's about the 2012 notice-based claims.
Okay.
Those exist in both actions. But the only argument here really is whether the notice of discovery condition bars them. We would say three things. Number one, if you look at what this court said in ABSHE 4, it said it was not a legal argument.
Doesn't whether or not the 2012 claims can go forward hinge on whether you have to bring the notice pre-action or not? And what that
No.
means?
Well, it shouldn't. I mean, because in both actions, notice was provided after the original 2012 action, but in
But after
2019,
it was provided after the 2012 action was commenced.
the original complaint was filed. That's correct. But those notices were provided well in advance of the 205A complaint in the 2019 action and well in advance of the amended complaint, the operative complaint in the 2015 action.
You're acting like an amended complaint is the same as 205A, but isn't amended complaint, it's still within the same court, same action, so it's not pre-action where arguably you can make the argument that 205 is not within the same action, so that they have different impacts.
Well, the 2015 case was a 205A complaint. So there was a 2012 complaint. That was the original complaint. Then,
Right, but it was of the 2012, so if the problem is in the 2012, bringing it again isn't going to help. Okay, thank you.
Well-
I think we got it.
okay, and just in conclusion, a breach is not a default. Thank you.
Very briefly, on the 2019 action and 205A, if that action was problematic as to AmeriQuest,
I'm sorry, if that
if
was?
that action was a problem as to AmeriQuest, that would mean that there can't be any backstop liability on DLJ's part.
Well, what about if the problem as to AmeriQuest is really just that it was not brought within 6 months of an action being discontinued as against AmeriQuest, which really wouldn't go to the merits, it's a different issue, which you don't have that same argument because of being in a different procedural posture.
But if they're not in the case, our liability is contingent on there being repurchase liability against them. So if there's not a valid action against them, we can't be liable as backstop. That's my only point.
Okay.
On the failure to notify claim, I believe that issue is controlled by the Equifirst recent decision that we addressed in our reply brief and in the proposed replies. And on the question of Section 7.04, default and breach. I think that issue is well covered in the briefing and in the ruling below. There's no ambiguity. The prior panel didn't resolve that issue. The trial court correctly held that Section 7.04 unequivocally requires notice that was lacking here as to the 1124 loans at issue in the original action.
Thank you. Thank you all. People versus Espanol.
Good afternoon, Your Honor. Stephen Strother from the Office of the Appellate Defender on behalf of Stephen Espanol. Your Honor, Mr. Espanol should be granted youthful offender treatment or have his sentence reduced to 8 years for a simple reason. He has been punished enough. In this case, he was savagely abused by corrections officers at Albany Correctional Facility in explicit retaliation for one of the crimes in this case. He was sent to Albany almost immediately after the assault on Officer Souffrant, taken off a bus, anally raped, had his hearing destroyed in his left ear, has penis stomped on so hard that he could not urinate except through a catheter, was thrown in solitary confinement without ceasing from that moment until he was sent upstate. And then,
I'm sorry, this was after the assault on Officer Souffrant?
immediately after. yes.
Immediately after. What happened in that assault with Officer Souffrant? Did he suffer physical injuries?
He absolutely
I'm not
did.
saying by any means the allegation. State. Wondering how did that plays into.
So I want to make clear, we are not saying Mr. Espanol did not do anything wrong. Officer Souffrant suffered serious injuries. We understand that it was an awful thing that he did. But what happened to him at Albany Correctional was just as bad, permanently life-changing. He pled guilty with these injuries visible. He spent many weeks in the hospital. He got out, they put him back in a room and did the same thing to him again, sent him right back to the hospital. This happened instantly after this assault on Officer Souffrant. It's not hard to draw the conclusion about why it happened. This was not taken into account at sentencing. The court instead explicitly told the COs in the audience, he praised them and said, Mr. Espanol will be punished for what's happening here. There was never a mention of what happened to him in Albany, except for the prosecution saying that our offer of 12 years is not influenced in any way by the treatment that happened to him at Albany. In other words, we don't care. This cannot be allowed. This kid has suffered enough. He will never be the same. And it's not just those factors. He had a lot in mitigation prior to what happened in Albany. He was 18 years old. It was his first felony, his first criminal case in adult court. He was homeless at the time of the offense for which he was arrested because his parents didn't care about him. His mother never filled his psychiatric prescriptions for his severe bipolar disorder. At any point, he was sleeping from couch to couch to avoid the streets. He had been shunted back and forth from the Dominican Republic to the United States with no explanation multiple times, tried to find his father who had no interest in taking care of him and basically kicked him out of the house. This is a kid who has never had a chance. He got into prison. He did something he should not have done. I don't want to minimize that to Officer Souffrant. It was a serious injury. But the CEOs, they punished him severely. And giving him a full decade in prison on top of that is not justice. And this court is the only court in position to take into account what happened to him. And so for that reason, we believe that he should be granted youthful offender. He has served 8 years in prison. He has enough time. He should be given a chance to have a real life on the outside. And if that's not going to happen, he should at least have his sentence reduced by a couple of years so that he can receive his good time credit and go home.
Counsel, was there any mention of the defendant's mental health issues, history at the time of sentencing?
So counsel presented a pre-pleading memorandum that outlined his mental health issues. So yes, it was out there. It was known. And it should be said that Stephen presents like a lot of kids that you see in this court who he's institutionalized a couple of times while he's in high school, right? For he gets in fights, he gets juvenile detention, and he does well.
There were two separate incidents here, not because we've been focusing on front. There was a shooting.
That's correct. He fired a gun at someone. It missed, fortunately, hit a brick wall.
I thought it hit someone in the foot.
It ricocheted off a wall and hit someone's foot. Mr. Espanol also shot himself, for what it's worth, during that on accident. Again, not his best decision, and someone got hurt. It's also pretty much exactly the kind of reckless and clearly dumb behavior that the Supreme Court and other courts have said is the hallmark of adolescent kids who have no guidance and no help. When he was in juvenile detention, he did well. The same has happened in prison. It's been no different there. He's been doing pretty well. He needs a chance to live a life free.
Just want to follow up on what my colleague asked you. Yes, he fired at the victim, but it was multiple times, and one struck him in the foot, right?
Again,
Multiple times.
I don't want to make it seem like we don't think Mr. Espanol did things that deserve punishment.
Right, but when you're asking us to consider this youthful offender issue, like let's set aside the sentencing issue. One of the things that we have to look at is the gravity of the crime.
That's correct. I don't dispute that the gravity of the crime is very serious here. But there have been cases of people getting youthful offender for serious offenses. And I think the law says that youth have a chance at rehabilitation. This is a kid who's never had a chance, ever. And I think he does now. Thank you, Your Honors.
May it please the court, Charles Wan for the respondent. Your Honor, first, defendant's valid waiver of his right to appeal forecloses his claim that he's deserving of a useful offender education or that his sentence should be reduced. And as to the sentencing, the trial court exercised proper discretion in deciding the defendant who basically was already in prison and waiting.
What about what happened to him when he went to Albany? Was that weighed by this trial court in terms of the sentence?
There was no discussion of it, so I don't believe it was. But then it is unfortunate what happened to the defendant, but it does not satisfy one of the factors.
I mean, unfortunate is kind of trivializing it, right? Yeah. Very serious what happened.
Right. I mean, it definitely should not have happened. What happened upstate should not have been done, but it is not. Doesn't meet one of the criteria for useful offender adjudication. It was not related to the crimes that the judge was supposed to consider in determining whether the defendant deserved useful offender education. As noted, he was already incarcerated, awaiting trial for which he admitted to having fired a gun with the intent to kill, and within less than 3 months, basically, he got 3 other inmates to act with him to attack a correctional officer, only solely because the officer had issued a ticket for infraction. And the officer suffered a broken neck as a result of the vicious attack. And here, the trial judge just only looked at the 2 charges that were before him, that the defendant was facing, and deciding that the defendant was not deserving of a useful offender adjudication.
Should we consider what happened to him in Albany in terms of his current excessive sentence application?
Again, that is not, it is unrelated to what the crimes that he committed. And again, I'm not trying to make light of what happened to him. It is seriously unfortunate, but they are unrelated. They're not factors that the trial court considered. I mean, in light of the viciousness of the 2 crimes that he pled guilty to, I mean, those are the factors that's supposed to really be considered here, not what happened to him afterwards. I mean, that I guess should be handled in a civil matter, not in necessarily as to what the sentence he is deserving of, whether he should be adjudicated as a useful offender.
And the sentencing judge knew there was a federal lawsuit with regard to the incident?
It's not clear because there is no discussion of it. I don't believe, if I recall correctly, I don't believe there was a discussion of it at the sentencing. So it's not clear how much of the other matters that the sentencing court was aware of. But it would appear the sentencing court basically just addressed the court's decision based on the charges that the defendant was facing. Thank you, Your Honors.
Thank you.
So certainly what happened in Albany matters. Judges consider post-offense conduct in sentencing all the time. If a defendant commits serious infractions in prison in between the time of indictment and sentencing, you better believe a prosecutor's going to bring that up at sentencing and a judge is going to take it into consideration. There should be no different here. What happened to him was punishment by COs for this offense. And I also want to mention, the federal civil rights.
Offense or a subsequent offense? Well,
What's
I guess
that?
That's included. Forget about it.
Oh, sorry. The federal civil rights lawsuit, I don't believe was mentioned to the court. Defense counsel did write many letters to the court urging that he be transferred from Albany back to Rikers, which never happened at any point. But the federal civil rights lawsuit, I don't believe, came up. And so, again, I don't think this was ever taken into account. I think everything from the record at sentencing shows that the judge was trying to ensure the COs that that Mr. Espanol was going to be punished, not that, in other words, it's okay what you did, I think is the message that was delivered there. Maybe not intentionally, but that is the message that gets across, and that can't be allowed to stand.
Thank you.
Thank you.
Corbex Inc. versus New York City Housing Authority.
Good afternoon, Your Honors. May it please the court, my name is Andreas Cudello of Volpe Brady Greenblatt on behalf of Corbex Inc., the appellant. We're here today because, in our view, the lower court's decision was based on an incorrect determination that Corbex failed to provide sufficient proof that NYCHA agreed to compensate it for extra work and that NYCHA had waived the notice of claim requirements under the contract under Section 33. We acknowledge that Section 33 exists, the notice of claim requirements exist, but here the difference is because of the conduct that NYCHA operated on this project in terms of the course of dealing with Corbex. And
what you're saying is that there were these negotiations as to these additional prices that it's been on for a couple of years, and it's kind of like they were leading Corbex on.
Your Honor, that's part of it, Your Honor, but respectfully, it goes beyond that in that the course of dealing between Corbex and NYCHA in this project also involved NYCHA going through the same process on multiple other change orders in terms of a negotiation, conduct the work to keep it on schedule. We don't want it to get delayed unnecessarily, and we will take care of it
What prevented
later.
it, though, from bringing a notice of claim immediately while it entered into those negotiations?
I'm sorry, Your Honor.
What prevented it from giving notice immediately while it entered into those negotiations?
So, Your Honor, what prevented Corbex here was because of that course of dealing, where payments were made on substantially larger change orders. One example being a $2.5 million change order that's reflected in on page 549 to 550 in the record by the Capital Projects Division. Because they had gone through this process and gotten compensated for all of their change orders to that point, they were given the reasonable belief that it was unnecessary
Counsel,
and that there was a mutual.
What about the fact that there's a very explicit provision in the contract prohibiting any estoppel against NYCHA, and that our courts have routinely enforced these estoppel provisions in the contract?
The courts do routinely.
Why isn't this a classic case? There's an estoppel provision, and based on that estoppel provision, we don't even have the power to invoke estoppel
Your Honor,
against
the
NYCHA.
difference between this case and the others that were cited by respondent in their brief, those said that instances of prolonged negotiations or even offers of settlement and contemporaneous informal notice, that those don't rise to the level of reaching estoppel.
None of them have really engaged in none of those cases really engaged in a fact-finding analysis. How much is estoppel justified? It's a very simple proposition that if there's an estoppel provision in a contract, that's it. You're done.
The difference here, Your Honor, is that because all of these elements are in play, not just one or some of them, and in conjunction with the course of dealing, which puts this case to defer to AHA General Construction, this wasn't a course of dealing, like in that case, where the court said that wasn't enough, where it was amongst multiple projects with different contracts, some having provisions, some not. Here, that course of dealing is all isolated in this single project where...
Do we have any cases where we say we're not going to apply a very clear and unambiguous estoppel provision because the course of dealing is so impressive and fulsome that we're not going to apply it?
Your Honor, I think that the circumstances in this case would put this under the limited application of what Bender allows. The Bender versus, the name is New York Hospital Corporation, where those circumstances is a very different fact pattern, but because of the type of, the course of dealing that took place here and the type of actions that NYCHA took that reasonably led Corbex to believe that there wasn't necessary, that this would be.
You're talking about what reasonably led, but you're not really explaining what prevented or hindered compliance with that notice and reporting requirement. I mean, to protect your own interests.
Your Honor, in
When I say your, I mean the.
Understood. Your Honor, in an ideal world, of course, I would like all of my clients to file notices of claims the day that they think a claim might arise, whether it does or not. As a construction attorney, that's a given. But in this instance, excuse me, what NYCHA essentially has done is take a provision in the contract that we acknowledge, and they say in their brief, is meant to protect and shield against the waste of public funds. Here, there's no question that that's not what it's being used for. It is being used as a sword against an unwitting contractor rather than as a shield against public funds. And it's essentially turning that provision, which has no real utility in the instance of this case, into a contractor forfeiture device to try to eliminate their claims. There are claims that were filed, that were paid out over a year, over 2 years after substantial completion, that were for substantially more sum, and it's frankly, it's arbitrary why this specific change order for a lesser sum was denied under a basis that was basically a mutual departure amongst the parties, that this notice of claim provision is not going to be enforced throughout the duration of the project.
May it please the court, Amanda McLaughlin for Respondent, New York City Housing Authority. For well over 20 years, the courts have consistently upheld and strictly enforced NYCHA's contractual notice of claim provisions. Compliance is a condition precedent to
What about
suit.
the case that he's citing to, that this case is like that case? What is its applicability or lack thereof?
Are you referring to Bender?
Yes.
Bender was an extraordinary limited situation in which two firefighters were unaware of their injuries because of exposure in a fire. The court there specifically said it was very limited and does not change the general rule that estoppel is not something that is applied in these situations with the government agencies. It's a very limited case that has nothing related to the facts in this case. This is a very basic construction notice of claim case that this court routinely handles and has addressed many times.
But then, I mean, just in this particular, under these particular set of facts, where other things were paid, and why couldn't they reasonably rely on that course of dealing?
The contract is clear that they cannot rely on the actions of NYCHA's employees to change the contract. The contract can only be changed by the board in writing. It's very clear in the contract that they have to file a notice of claim, that the notice of claim is a completely separate process from these proposed change orders. So the proposed change order process, there's many levels of review. It goes to construction managers, it goes to lower level employees at NYCHA, it eventually works its way up the chain. It can be denied at any level. It's not related to the notice of claim. The notice of claim goes to the contracting officer, a high level employee at NYCHA. It's very different. It informs us of legal action. It's not about whether construction should happen or not and what that price for construction should be. Now, this court has routinely held that NYCHA's contractual notice of claim provision must be strictly complied with. The court below found that it wanted to follow that court's extensive precedent, and it correctly dismissed Corbex's complaint for failure to comply with the notice of claim provision. The notice of claim provision is clear. Corbex needed to file with NYCHA's contracting officer a written notice of claim within 20 days of the claim arising. That notice needed to state the nature and amount of extra costs and damages and the basis of its claim. And all elements of the notice are independently required. Now, in this case, Corbex's notice of claim wasn't a little bit late. It was years after its claim arose. And because Corbex's notice did not comply with the requirements, it is deemed to be a binding and conclusive determination that Corbex has no claim against NYCHA. All of Corbex's arguments have been previously addressed by this court and found not to apply to NYCHA's notice of claim provision. There's nothing novel about this case. Now, there is not a single date that Corbex can point to that would show that its notice was timely, whether we're looking at when Corbex alleges that it was directed to perform the extra work, when the proposed change order was denied, or even substantial completion. This court has routinely held that a claim accrues when damages are ascertainable. So on August 6, 2018, Corbex stated that it knew it had to pour double the amount of concrete. It was at that time that its damages were ascertainable. So part of that is construction contractors, they're routinely asked to do detailed bids way before they do the work. So in that case, Corbex would have been able to calculate the cost of this work. And not only would it have been able to, it did in fact calculate the cost of the work. It submitted a cost proposal in August 2018.
Not as a notice of claim.
Not as a notice of claim, just as presumably part of the proposed change order. Now, if we look at substantial completion, which this court has routinely held as the latest point at which a notice of claim would need to be filed, substantial completion was May 29th, 2019, years before the notice of claim was filed. Now, at substantial completion, the work's already done. The costs have already been incurred. Corbex definitely knew at that point how much money it had spent on the project and could have done a notice of claim. Now, this court has consistently held that the claim does not accrue when change orders are denied or when negotiations are finalized. But even if Corbex's claim did not accrue until its change order was denied, it still filed its notice 41 days after that date. There's no date from which it was timely. Now, instead of dealing with the fact that its notice was late, Corbex has been trying to focus on estoppel, which, as we've discussed already, is not applicable in this case. NYCHA has a clear no waiver or estoppel provision in its contract, and the only way to show estoppel in this situation would be for NYCHA to have actually prevented submission of a timely notice of claim. And that's not simply negotiating a proposed change order or discussing a payment. It has to actually prevent the submission of the notice of claim. This court has held that negotiation is not enough. And in this case, the only thing that Corbex has alleged is that NYCHA's construction manager negotiated a change order. There was no proof of any promises that they would be paid, and even if there were, that still is not enough to not require them to submit a notice of claim. That is a mandatory, strict compliance requirement of the contract that this court has routinely upheld. Now, it hasn't been discussed as much today yet, but there's also two other grounds in the papers for which that the complaint could have been dismissed for. So in addition, Corbex cannot seek compensation for extra work that NYCHA did not authorize, as NYCHA did not issue a written order directing Corbex to perform any double concrete work, which is required by Section 36 of the contract. And as we've discussed, the no waiver provision does not allow for waiver of the written terms of the contract without the board resolution. And also, Corbex failed to conduct a pre-bid inspection. Without conducting a pre-bid inspection, Corbex cannot now benefit from its failure by arguing that the differing conditions prevented it from knowing that it would need to do double the concrete when it could have just looked and seen before it even bid. Thank you.
Your Honors, I'd like to first touch upon the reasonably prudent bidder standard cited by counsel. That one should be the easiest thing to discuss. Here, these are subsurface conditions, latent discrepancies on surveys that were based on 1950s drawings that NYCHA never did their own inspection to go and verify. There was no way in order for Corbex to ever have discovered any of these conditions until actually excavating the site, which required...
There was a point at that time when they realized they would need to use a double level of concrete, right?
I'm sorry, Your Honor?
There was a point then when they realized they would have to use a double amount of concrete.
During the course of the project, and contrary to...
Why wouldn't that be the appropriate date from which to measure the time to file the notice of claim?
Your Honor, that Could be, the damages were not ascertainable at that time because Corbex had excavated 1 out of 28 of these sellers.
That was in 2018.
That was in 2018.
What about if we use the 2020 substantial completion date?
Your Honor, you could use the substantial
It would
completion
still
date.
be untimely.
But that's where we come into the course of dealing here. There's no reason why NYCHA then, under that same argument, shouldn't have rejected the $2.5 million change order that related to these same seller subspaces where additional insulation was needed because of the discrepancies between those in the site conditions and the drawings. NYCHA is just arbitrarily choosing which change orders they wish to deem or not. Here, there was not just a cost proposal given in 2018, multiple revisions of cost proposals because obviously the damages weren't ascertainable. They kept changing as the work was being proceeded with. And as NYCHA proceeded to go and compensate Corbex with no notices of claim on any other change orders ever filed. The only basis really here that these claims were denied, that were dismissed in the lower court, is the failure to file a notice of claim. It's not a matter of a change order being proceeded with without having being actualized with a written change order.
Thank you.
I'm sorry. Thank you, Your Honors.
Dape Consulting?
Good afternoon. May it please the court, Joshua Androphy for Appellant Dape Consulting, Inc. This is a simple case for an account stated, and summary judgment should have been granted in favor of the plaintiff. Here, Dape Consulting provided carrier services to Next Trucking, and it invoiced Next Trucking accordingly. Next Trucking did not voice any dispute over the invoices. They partially paid the invoices, but left a balance of approximately $142,500. Summary judgment should have been granted because DapeCon established that tendered invoices to Next Trucking, which Next Trucking retained and was silent about, and that is all that is required to establish an account stated. There's no dispute in the summary judgment record over whether these invoices were provided to Next Trucking, and there's also no dispute over the fact that Next Trucking was silent.
Was there any objection articulated?
No, not until the lawsuit was filed and this motion for summary judgment was filed, and then only in opposition did Next Trucking provided the affidavit of Yolanda Simon, and within that identifies...
Which appeared to be an inverse version of your calculation, right?
Right. Well, that identifies the purported disputes that Next Trucking claims it has with the invoices. But Ms. Simon's affidavit, nowhere does it say we raised these issues. We identified these disputes at any time before this lawsuit and Dape Consulting filing for summary judgment. Dape Consulting in their affidavit, specifically in reply, says they never did that. They never disputed this, and there's no evidence to the contrary. There's no evidence that Next Trucking ever raised any dispute before this lawsuit and even before the summary judgment motion saying these are the reasons why we're not paying these invoices.
Thank you.
Thank you.
Jawara versus Araka? She came late. She came late.
Good afternoon, Your Honors. May it please the court. My name is Irene Wanyangu with Anelli and Associates, and I'm here on behalf of the appellant. So, Your Honors,
Let me ask you, there was a down payment, and then it's undisputed that the plaintiff asked for the down payment back, took the down payment back, and never issued another check for a down payment. So there was no down payment for the purchase of the property. Under those circumstances, why should the plaintiff get specific performance when it undisputedly did not give a down payment?
So, Your Honor,
Took back the down payment.
Your Honor, contracts of sale are usually conditioned on the purchasers putting down a down payment. And in this case, the purchasers put down a down payment. The court, the lower court found that.
But it took it back.
I'm sorry, Your Honor?
It took it back.
Yes, but there was already a binding contract. And once there's a binding
But that
contract.
contract was also conditioned on other, you were supposed to secure funding, and that part didn't happen, and that was what was taking so long. But in terms of the down payment, because I think you really need to, you're asking for specific performance, there really needs to be proof that that down payment was tendered. While it was at one point, once you take it back and don't reissue a new check or put forth a new down payment, that obligation hasn't been fulfilled.
Yes, but Your Honors, a party that is aware that the other party is about to breach a contract, once there's a binding contract, has a duty to notify the other party of their breach and give them an opportunity to cure the breach. So in this case.
But your client had no reason, I mean, your client should have been well aware that there was a breach because they didn't put down a down payment.
Right, but Your Honor, they gave a down payment which sat with the seller's attorney. They didn't deposit it. It was a certified check. So at some point they said, give it back. At that point, there was already a binding contract. If they had issue, if the seller had an issue with the check not being there, they're supposed to have notified them of the potential breach and asked them to reissue another down payment check.
Okay, well, let's get to the point of being a ready, willing, and able purchaser, right? Because the commitment letter that you received, it was conditioned on receiving a donor amount of $35,000, right?
Yes, Your Honor. I believe that's the situation.
Was there anything in the record that indicated that that condition had been met?
No, Your Honor, but seller had the right to cancel the contract if purchasers failed to get a mortgage commitment that they could use to purchase the property. But the contract of sale, the binding contract of sale between the two parties specified when seller could or what seller's rights were.
But counsel, the issue isn't only whether the seller had the right to cancel, but whether your client had a right to full performance when it was not ready, willing, and able to close.
Your Honor, if seller doesn't cancel within the number of days specified in the contract, which they didn't, then they're basically accepting for the purchaser to purchase. Purchaser has waived the right to purchase pursuant to a mortgage commitment, meaning if they don't get the mortgage commitment, purchaser was still bound to buy. Seller
Counsel, if I may, time was not of the essence here in this contract, so how could you say that?
That's a good point, Your Honor. If time wasn't made of the essence, it has to be made of the essence before the seller can cancel the contract of sale. The way it happens is if...
I was just going to say, to get specific performance, you need to establish that you're ready, willing, and able to purchase, but that was not done.
Yes, Your Honor. However, seller failed to cancel the contract as outlined in the contract of sale. The contract of sale has the procedures through which seller can cancel the contract.
So even,
and seller,
I guess I'm just concerned, even if we accept all of that, you took the down payment back, it never was tendered, you got a commitment letter, you hadn't necessarily met that commitment, and then you're at the closing at that time, how were you ready, willing, and able at that time? Even if they hadn't canceled the contract, how were you ready, willing, and able at that time?
even when specific performance is not given, like the decision doesn't give purchaser what they're requesting, which is specific performance, we still have to go through the analysis of was the contract breached. In this case, seller failed to do that. Seller again failed to cancel the contract pursuant to the procedures outlined in the contract of sale. So if seller fails to cancel the contract, it means that the contract of sale is still binding between the parties.
Thank you. Thank you very much.
Good afternoon, Your Honor. My name is Joseph Obiora, appearing for the respondent in this case.
So, counsel, it's not disputed that there was no, that the letter terminating the contract of sale was sent on March 7th, 2022, right?
Yes, Your Honor.
And that was after the holdover proceeding, after Supreme Court had issued its ruling, the first judge in February of 2022 saying that you never terminated the contract.
Correct.
Okay. And a trial was held?
Yes. Yes, Your Honor.
Okay. How was specific performance not shown? And I know I'm asking that question.
The point is, the relief they're asking for is for specific performance. That's the appeal. And we have to present it and beam the light on it. The principle about specific performance, does it apply for the court to grant it to them? One, there's never been a down payment. Originally, it started from beginning to breach the contract. No down payment was made.
Well, they did make the down payment, but it was never deposited, right?
No, there was none. The first down payment was tied to a contract that the seller never signed because they brought in some conditions that were not acceptable. So that one down payment was made in May 2018. By July of 2019, the parties now had agreement on the terms of the contract, and then the seller had changed the attorney. So the buyer's lawyer had to write to ask the original lawyer who had the down payment to give it back to them so that they will reissue it to the new attorney working for the respondent.
And that was never done.
It was returned to them, the bank, they put the money in the bank. They never paid any amount again. So we now have a situation in which they are in this court on a contract they never made a down payment on. Even though they requested for the money, they put it in their bank, then they commenced this action. If you look at sequence of events, you will find out that even the commitment, the ordering of the title, they were all tailored to a few weeks before they began this court case, so that they would just give indication.
Thank you very much, counsel.
Thank you, Your Honor.
Thank you. You didn't, there's no rebuttal.
He wasn't here.
I know, but we gave you a lot of extra time. You had way more than 2 minutes. Thank you.
He wasn't here to rebut because he wasn't here when we.
Counsel, I'm not going to change it now. Thank you.
You're not.
Thank you.
I requested 2 minutes because he wasn't here for rebuttal.